You're listening to Portfolio, the property law podcast from Davis Blank Furness.
Hello and welcome to Commercial Property Insights, the podcast from Davis Blank Furness, where we unpack the legal complexities of commercial property in a way that's practical, accessible, and genuinely useful for you, our listeners. I'm Rosie Korch, a partner in the commercial property team. I focus on transactional work, helping businesses, SMEs, and high net worth individuals navigate property acquisitions, disposals, and leases.
And I'm Sean Hackett, head of the property litigation department here at Davis Blank Furness. And whilst Rosie is dealing with deals, I'm often picking up the pieces when things go wrong. Disputes over lease terms, forfeiture proceedings, dilapidation claims, that sort of thing. It's a different perspective, but both sides of the coin are crucial to understanding commercial property properly.
Absolutely. Today, we're kicking off our portfolio series with a topic that sounds deceptively simple, but trips up businesses and their advisors time and again. The difference between leases and licenses, and when you'd need something called an agreement for lease. Some might ask, do I really need a formal lease? Can we just sort out a license? Or perhaps, why is the solicitor insisting on this two-stage agreement for lease process? These aren't just academic questions. Getting the structure wrong can have significant tax implications, affect security of occupation, and even impact whether the tenant is protected by some very important legislation.
That's right. And from my litigation perspective, I see the consequences when people get this wrong. A business thinks that they've got a simple license, maybe because the document says license agreement in big bold letters at the top, and then suddenly they find they're actually created a lease by accident, which brings in all sorts of statutory protections under the Landlord and Tenant Act 1954. Or conversely, they think that they've got security of tenure, but actually they've only got a license and they're out on their ear with minimal notice.
So let's start with the fundamentals. What is the legal difference between a lease and a license? Before I invite you to answer that, Sean, I should point out that people, including legal advisors, often use the terms lease and tenancy agreement as if they are the same, which they are not.
And that's really important. When we think about a business and occupation of a property carrying on their business, say a manufacturing company in a warehouse, they occupy the warehouse under a tenancy. The tenancy is the creature which exists in law. It's an invisible legal creature. If there's a document which records the terms of that tenancy, that document is the lease.
And of course, you can have a tenancy without a lease, but the topic of periodic tenancies is for another day. For the purpose of this podcast, when we refer to the lease, we are talking about the tenancy. So before we can answer the question, what is the difference between a lease and a license? I suppose we need to understand what a lease is first.
Okay, so to understand what a lease is, we need to look to the landmark case that everybody in property law has to know about. It's Street versus Mountford from 1985. It's a House of Lords decision that's still the leading authority today, some 40 years on. In that case, Mrs. Mountford signed what was expressly called a license agreement to occupy 2 rooms. The landlord, Mr. Street, was a solicitor, so he knew what he was doing when he drafted the document. The agreement said in its terms that it didn't create a tenancy, but Mrs. Mountford wanted to claim protection under the Rents Act, which only applied to leases and not licenses. So the question, was this really a license or was it a lease? That had to be decided, and it went all the way to the House of Lords. Now, Lord Templeman gave the leading judgment in that case, which really cut through all the technical arguments. He said, and I'm paraphrasing it here, if an agreement grants exclusive possession of property for a term certain at a rent, then it creates a lease. It doesn't matter what you call it. You can't simply label something a license and expect that to be determinative. And to use Lord Templeman's famous analogy, he said, if you manufacture a 5-pronged implement for manual digging, it's a fork, even if you insist upon calling it a spade.
I love that. What matters is the substance and not the label. So the key elements for a lease are exclusive possession for a term certain at a rent. Shall we unpack those for our listeners?
Sure. So if We can take them in reverse because rent is, as you would expect, payment in some form. A valid lease requires what they call a term certain, meaning the maximum duration of the lease must be clearly defined from the start. Any wording in the lease which provides for an indefinite continuation of the lease means the term is uncertain. And that's been the issue before the Court of Appeal in the AP Wireless versus On Tower case that the Court of Appeal dealt with this year. The court held that an agreement for a minimum term that continued indefinitely until terminated by notice was void as a lease due to the term being uncertain, and instead the agreement constituted a contractual license. Finally, and crucially, a valid lease requires exclusive possession. This means the occupier has the right to exclude everyone from the property, and that includes the landlord, subject only to the landlord's limited rights to enter for specific purposes like inspection or carrying out repairs. And if a party is occupying a room, but the property owner has unrestricted access or provides services that require them to come and go, like a hotel or serviced offices, then the occupying party is more likely to have a license.
Okay, so one more time for the kids at the back. A valid lease needs a rent, a definite term, and for the tenant to be the only party using their space. Fine. We now need to understand what a license is.
Okay, well, a license is essentially a personal permission to occupy or use someone else's land. It doesn't confer exclusive occupation. Think of it as permission that prevents your occupation from being a trespass, but it doesn't give you any what we call proprietary rights in the land. Examples might include a market stall holder, someone with a desk in a co-working space where the operator retains control, or a concessionary in a department store, or a crane on a building site where the boom overhangs the neighbouring land.
Okay, so if those three components exist, exclusive possession of a property for a term certain at a rent, then it creates a lease. But if they do not, then you have a license, and vice versa.
Exactly. So now we know what a lease is and what a license is. Many will wonder, why would you want a license over a lease?
There are good reasons why parties might want a license rather than a lease. For the property owner, who are the licensors, not the landlords, by the way, the main advantage is flexibility. Licenses can typically be terminated more easily, often on relatively short notice, without the need for court proceedings. There's no security of tenure under the Landlord and Tenant Act 1954, which is a huge difference, and we'll come to that in our next episode. From an occupier's perspective, who is referred to as the licensee, not the tenant, they are giving up the certainty of being in occupation of the property in return for the agility and flexibility of being able to end the license more quickly than they could do with a lease. So let's say we have a startup retailer who wants to trial a pop-up shop for 3 months in a shopping centre. They approach centre management, who offer a licence. That may well be perfectly appropriate. The licensee gets to test the market without long-term commitment, and the licensor retains maximum flexibility. But the licensee needs to understand, if the arrangement is working brilliantly and they want to stay, they have no legal right to remain beyond the licence period. The licensor can simply say no, even if the tenant has spent a fortune on their fit-out.
Indeed. Now contrast that with a lease. If you've got a business lease for a fixed term and you're occupying for the purposes of business, then Part 2 of the Landlord and Tenant Act 1954 will typically apply. That gives the tenant security of tenure that you mentioned a moment ago, Rosie, which we're covering in our next podcast. The security of tenure is a statutory right for the tenant to remain in the property at the end of the contractual term which is stated in their lease and to request a new tenancy. The landlord can only refuse on one of the 7 statutory grounds, some of which carry compensation obligation, and that's a much stronger position for the tenant, but correspondingly it ties the landlord's hands.
Which is precisely why many landlords insist on contracting out of the 1954 Act. But that's our next episode. For now, the point is, if you're a business tenant and you're investing in fitting out the premises and building up goodwill in your location, you generally want the certainty that comes with a lease and not a license. Whereas if you're a landlord who values flexibility, or you've got a short-term situation, you might prefer a license if you can genuinely structure it in that way.
Yeah, but here's the trap. You can't just decide you want a license, call it a license, and have that be the end of the matter. Remember the decision in Street and Mountford. The courts will look at the reality of the arrangement. If you're granted exclusive possession for a term certain at a rent, you've created a lease, whether you've intended to do so or not.
And there are consequences. For one thing, stamp duty land tax, or SDLT. Leases over a certain threshold attract SDLT. The thresholds and rates are set out in the Finance Act 2003. Broadly speaking, if you're granting a lease with a value above the nil rate threshold, which is currently 150 grand for commercial property, though they do change, SDLT becomes payable. Licenses, on the other hand, generally don't trigger SDLT because they're not grants of an interest in land.
So you can see the tax planning angle. If a client structures an arrangement as a license and it genuinely is a license, they might save SDLT. But if HMRC or the court later determines that it was actually a lease, you're potentially got an underpayment of tax with interest and possibly penalties.
Exactly. So the advice to any business advisor is, don't assume you can save SDLT just by calling something a license. You need to look at the substance. Is there genuine exclusive possession? If the occupier is taking the whole of defined premises, paying rent, and the grantor has only limited rights of entry, it's almost certainly a lease, no matter what the document says.
Now, there are some situations where a license is clearly appropriate and won't be recharacterised as a lease. For example, if multiple unconnected occupiers share a space with no individual having exclusive possession of any part, that's more likely to be a license. Or if the arrangement is genuinely very short-term, a few days or weeks, and it doesn't involve exclusive possession, that could be a license as well.
Yeah, and I've got another example that is becoming more common, event spaces. If your client is hiring a venue for a one-off corporate do, a wedding or a conference, that's typically a license. There's no intention to create a legal estate in land, just a permission to use the space for a specific occasion. Similarly, advertising hoardings, where someone's paying to display their adverts on the side of a building, that would be a license, not a lease.
So far, we have looked at what a lease is, what a license is, and the difference between the two. We'll come back to leases in our next podcast when dealing with the very important security of tenure topic. One thing we've not yet discussed is the topic of agreements for lease, which, as the name suggests, is an agreement between two parties to enter into a lease. Rosie, in your transactional practice, when would you advise a client to enter into an agreement for lease rather than going straight to entering into the lease?
Yeah, it's a really common structure in commercial property, particularly for new developments or where there's a lot of work that needs to be carried out to the property before the tenant can occupy. An agreement for lease is essentially a contract to grant and take a lease in the future. It sits alongside the actual lease, which won't be completed until certain conditions are met.
So it's a multiple stage process. Can you walk us through what that process would entail?
Yeah, each scenario will be different and it really depends on what the parties have included in the heads of terms. Once the heads are agreed by the agent, the lawyers will wade in to negotiate the agreement itself. Timescales, obligations will be carefully documented. And there may well be a contracting out stage if the lease is to be contracted out of the security of tenure under the 54 Act. Then you come to the exchange of the agreement. The exchange makes the agreement legally binding. From that point, both parties are committed to taking the agreed form of lease once the conditions have been met. So, once the conditions are satisfied, the parties are obliged to complete the lease and everything is put in place.
But many will be asking, why would you go to that trouble? Why not just enter the lease now to start in the future, or just wait until the parties are ready to enter into that lease?
Oh, there are loads of reasons. The most common is development situations. So let's say your client is a coffee shop chain. They're looking to take a space in a new shopping development. It's not constructed yet. They don't want to take the lease now because there's nothing to occupy. But they do want to take up their unit when the development is complete. And so they will enter into an agreement for lease. If you look at it from the shopping centre owner's point of view, they will typically be building with development finance. They and their funders will want to know that tenants will be taking up occupation, paying rent once the development is complete. The shopping centre owner will want the tenant committed to taking that unit, and so they will enter into an agreement for lease. The agreement might say, and I'm simplifying it here, when the landlord has carried out the base build works to the following specification and obtained completion certificates from building control, the lease will be granted. That gives both sides certainty about their future relationship, but defers the actual grant of the lease until the property is ready for occupation.
Yeah, and from a litigation perspective, that would make sense. If you granted the lease immediately, the tenant would have legal estate and land, and all the associated obligations would start to accrue, such as rent, repair obligations, even though they can't actually use the property, and that just wouldn't be workable. The agreement for lease keeps things contractual until it's appropriate to create that leasehold interest.
Another common scenario is where the tenant needs to obtain planning permission for their intended use or consent for specific works. So perhaps you've got a client that wants to convert retail premises into a restaurant or an industrial unit into a gym or a doggy daycare. They need planning permission and building regs approval. They don't want to complete the lease and start paying rent until those consents are in place and that they know they can definitely use the property for their business. But the landlord wants commitment. An agreement for lease with a condition precedent about planning permission solves the problem for all parties.
So we've both mentioned that the topic of security of tenure under the Landlord and Tenant Act 1954, which we'll cover in our second podcast, but you said that there may well be a contracting out stage that will need to be followed at the outset of the agreement for lease process. I think we need to say more about that. Can you elaborate on it, Rosie?
Yeah, sure. The crucial point is that if the parties intend on contracting out of the 54 Act, and we'll talk about that much more next time, you need to complete the contracting out procedure before the parties become contractually bound. That means if you're using an agreement for lease, you must serve the warning notice and get the tenant's declaration before you exchange the agreement for lease, not before you complete the actual lease. I have seen deals grind to a halt because people get those timings wrong.
That's a really important practical point. The Regulatory Reform Business Tenancies England and Wales Order of 2003 sets out the procedure that the landlord must serve a warning notice on the tenant, and the tenant must make either a simple declaration if the notice was served at least 14 days before the parties become contractually bound, or a statutory declaration before an independent solicitor if it's less than 14 days. But becoming contractually bound means the agreement for lease, if there is one, and not the final lease itself.
Yeah, exactly. So if you're acting for a landlord and you're using an agreement for lease, you need to factor in time for the contracting out procedure before you exchange the agreement. It's not something you can just tack on later. Now, that said, if the lease isn't being contracted out, so it is going to be protected by the 54 Act, then you don't need to worry about this particular issue, although you do have other considerations, which we'll discuss in episode 2.
So let's talk about SDLT again in the context of agreements for lease. How does that work?
It's a bit of a quirk in the system. Generally speaking, SDLT becomes chargeable when the lease is actually granted, not when you exchange an agreement for lease. That makes sense because until the lease is granted, there's no interest in land. But, and this is important, so wake up if you have fallen asleep, if the tenant takes possession under the agreement for lease before the lease is granted, SDLT can become payable at that earlier point. Possession means actually occupying the property or receiving rent from it. So let's say you exchange an agreement for lease and the agreement allows the tenant to go into the property and start fitting out before the lease is formally granted. That is taking possession. SDLT potentially becomes payable at that point, even though the lease hasn't been granted yet. It's all calculated on terms that will apply once the lease is granted.
Yeah, and that's a trap for the unwary. Clients often want to start work on the property as soon as possible, but if they do so before completing the lease, they might trigger an earlier SDLT payment liability.
Exactly. The way we tend to deal with this in practice is to negotiate an access license for works. This license will not grant exclusive possession, but will allow the tenant to carry out certain works subject to limitations on duration and insurance, so it can be done. It just needs to be done properly. There's another SDLT issue with agreements for lease, which relates to substantial performance. If an agreement for lease is substantially performed, which usually means either the tenant takes possession or a significant proportion of the consideration is paid in respect of the lease, that triggers SDLT. Then, when the lease is actually granted, you have to file another SDLT return and pay any additional tax. It's administratively burdensome and can catch people out.
So what's the practical takeaway for advisors, Rosie?
A party to an agreement for lease who is going to be the tenant under the lease to be granted needs to think very carefully about whether they will take possession before the lease is granted. If they will, for example, to carry out fitting out works, they need to understand that the SDLT may well become payable at that point, not when the lease is completed later. So factor that into your cash flow and keep on top of your filing deadlines. Remember, there is a 14-day deadline from the effective date to file the SDLT return and pay the tax. Otherwise, the taxman will start to send you penalty notices.
So now we know what an agreement for lease is and how it might be used. Let's bring all of the things we've covered together, Rosie. Can you talk us through a typical scenario where, say, an SME client might benefit from understanding these distinctions?
Sure. So let's imagine a small manufacturing business. They've outgrown their current premises. They found a lovely new unit on an industrial estate. The landlord is offering what he calls a license to occupy for the first 6 months, after which it'll convert to a lease. His reasoning is that the unit needs some remedial works, and he doesn't want to commit to a long-term tenancy until the tenant has established that the premises suits their needs.
So right away, alarm bells should be ringing. If the tenant is taking exclusive possession of the entire unit, paying monthly license fees, that are in real terms rent, and the landlord only right to enter is for inspection and repairs, well, that's probably a lease, not a license, regardless of what the document says.
Exactly. And if it is a lease, several things will follow. First, unless the 54 Act has been properly contracted out, the tenant will have security of tenure after the 6-month period expires. The landlord can't just terminate on notice. They'll need to follow the statutory procedures that we'll cover in our next podcast. Second, SDLT will potentially be payable on grant of the lease. And third, the tenant's got stronger remedies if things go wrong. They can't be evicted without due process.
But let's say the landlord genuinely wants flexibility and the tenants are happy with that short-term arrangement because they're not sure that the location will work for them. Can you structure it as a true license?
Well, it's difficult if the tenant is taking exclusive possession of a defined unit. The Street and Mountford principles are hard to get around. One option might be a short-term tenancy, say 3 or 6 months. They will not have security of tenure, protections afforded by the 54 Act. And that way, both sides get certainty about the legal process. The tenant knows they've got a lease with exclusive possession rights, but the landlord knows it will end on a fixed date without any right of renewal. Another option, although it is more complex, is to genuinely share the space or retain meaningful control. But that's often not practical, especially for a manufacturing business that needs to control access for health and safety reasons.
Yeah, and here's another scenario. A client wants to sublet part of their existing premises. They're a tech company with a large office and they want to put someone on a desk in the corner to cover costs. They're thinking, let's just do a quick license. What would your advice be there?
Okay, so my first question would be, does your lease permit subletting? Many commercial leases have an absolute or qualified prohibition on alienation. This includes any right to sublet. If it's absolutely prohibited, you can't do it at all. And if it's fully qualified, for example, not to underlet without the landlord's consent, not such consent not to be unreasonably withheld, you need to apply for consent and pay the landlord's legal costs of dealing with the application.
And if they do it without consent and it's prohibited or they haven't obtained consent, that's a breach of covenant. The landlord can take forfeiture proceedings to terminate the lease, and we see that a lot in litigation.
Exactly. So assuming they can sublet, the next question is whether they're granting exclusive possession. A single desk in an open plan office where the tech company retains control and provides services will probably genuinely be a license. But if they're letting a self-contained office suite or even just a defined area with lockable doors, that's probably a lease. And here's a really important point for the tech company. If they are subletting, they probably want to make sure the sublease of that self-contained office suite ends no later than their own head lease. Otherwise, they could end up with a situation where their head lease expires, but the subtenant has continuing rights. And to say that is messy is an understatement.
Well, what about the 1954 Act in subletting situations? Does that apply to subleases as well?
Oh yeah, definitely it can. If the sublease is of a premises occupied by the subtenant for business purposes, Part 2 of the 54 Act applies unless it has been properly contracted out. That's another reason landlords often require their tenants to ensure that any under-tenant contracts out of the 54 Act when granting an under-lease.
Okay, now we're coming to the end of our time, but let's do a quick summary for the listeners. What are the key takeaways from today's discussions?
First, understand that the distinction between a lease and a license is fundamental, and it's determined by substance, not labels. Remember Street and Mountford, a fork is a fork, even if you call it a spade. If you've got exclusive possession for a term certain at a rent, you've created a lease, whether you call it a license or not.
And second, the consequences of having a lease versus a license are significant. Leases typically bring statutory protection under the Landlord and Tenant Act 1954, conferring security of tenure on business tenants. Licenses don't. Leases can trigger SDLT. Licenses typically don't. And leases give stronger remedies and protections, but also more obligations.
Third, there are legitimate reasons to want a license: flexibility, short-term arrangements, tax planning, but you need to structure it carefully to ensure it genuinely is a license. If in doubt, assume it's a lease and take advice.
And fourth, agreements for lease are useful in situations where you want to commit granting a lease in future, but certain conditions need to be satisfied first. Common examples include development projects, planning permission requirements, or works needed to be carried out. But remember, if you're contracting out of the 1954 Act, you must complete the procedure before exchanging the agreement for lease.
And finally, SDLT needs careful attention. Taking possession under an agreement for lease can trigger SDLT earlier than you might expect. Mislabeling a lease as a license does not avoid SDLT if it's actually a lease in substance.
Yeah, I think that's a great summary. Next time on Commercial Property Insights, we'll be diving deep into the Landlord and Tenant Act 1954, what security of tenure actually means, how contracting out works, and the notices and procedures that landlords and tenants need to know about. It's one of the most important pieces of legislation for commercial tenants and one of the most commonly misunderstood, so we'll have plenty to discuss.
And we'll also be talking about a really interesting issue. Can you insert an option to take a further lease into a contracted out lease? It sounds technical, but it has big practical implications for tenants who want some long-term assurances. Until next time, thanks for listening to Commercial Property Insights from Davis Blank Furness. If you've got questions on anything we've covered today, get in touch by visiting our website, www.dbf-law.co.uk. Take care.